Hello and welcome to the FMA workshop on arbitration and early neutral evaluation, which is being presented by Marcus Lazarides. Hello, Marcus.
Hello.
Welcome to the FMA. So just as an introduction to Marcus, Marcus is a barrister who specialises in financial remedies and he works at QEB, Queen Elizabeth Building. He's a qualified and experienced arbitrator and has conducted a number of private FDRs as well. He's listed in Chambers and Partners and the Legal 500. Chambers and Partners describes Marcus as having excellent judgment, which must be rather nice when you're working as an arbitrator.
Quite useful.
So I've got a series of questions so that we're trying to make this more interactive and more workshop-like and less like a lecture, which is why Marcus has asked me to ask him a series of questions. Marcus, first basic arbitration and EVA 101. What is early neutral evaluation?
Early neutral evaluation, certainly as I've experienced it, is really just another form of, or completely akin to, the private FDR. And I thought it might be helpful if I explained a little bit about how the FDR process, the financial dispute resolution process within court proceedings, came about. And that then, I hope, feeds into why I think it's something which can be used within a mediation process or can be tacked onto a mediation process. Effectively, what happened was that in the late 90s, judges were becoming increasingly frustrated by the fact that cases were coming in front of them for final hearing at huge emotional and financial cost to the parties. They'd open the papers, they'd look at the problem they were being asked to adjudicate on and pull their hair out as they screamed, "But I can tell you what the answer is to this. It's blindingly obvious. Why didn't somebody ask me sooner?" And so a process was developed whereby they could be asked much sooner to give the indication, to give the blindingly obvious answer at a without prejudice hearing, not binding on anybody, but to give everybody the opportunity to go, "He's right, isn't he? The answer is blindingly obvious. Why don't we get on and settle this before we spend any more money and before we fall out even more than we have already?" And in the early days, those court FDRs were very successful. I don't have facts and figures, but I can tell you anecdotally and from my own experience, I would say that very rapidly I got to a stage in my own practice where at least 80%, maybe more, of the cases that I was involved in were settling at the FDR, and then a proportion of the ones that didn't settle, settling quite soon afterwards. Unfortunately, the pressure on the court process, on the court timetable and on the judges meant that rather than finding that you'd been listed in court in front of a judge who was maybe going to hear 3, 4 other FDRs during the course of the day, with a court administrative process behind him or her who had made sure that they had the right papers in front of them, that they knew what the case was about, that any notes that had been produced by counsel were there and to be read, had arrived properly on time, and they had a proper knowledge of the case and time to deal with it. All that fell away. And we found that you were turning up at court, possibly on a list of half a dozen or more cases, with other cases being put in. The poor judge hadn't got your documents, hadn't got the papers, didn't really know what the case was about. That then became apparent to the clients, and suddenly they're thinking to themselves, well, why would I be interested in what this man or woman has to say to me about what the answer to this case might be? They don't seem to know what's going on. They don't know how many children we've got. They don't know where we live. Why should I trust their indication? And so they started to become less effective, but no less costly, because you would still do the same amount of preparation. You would still go into it hoping it was going to work. And so we came up with an alternative. And it was an alternative which I think originally was really very much for those people who had enough money and whether it was felt that the case warranted the private FDR, which was a little bit akin to opting for private medical care. You opted out of the NHS so that you could actually be certain that you would see your consultant, see your surgeon on a particular day, and they would have all the information in front of them. But what became clear very early on was that there was no reason at all why these hearings, these private hearings, should only be conducted in cases where there was large wealth and substantial assets, because actually they worked, and they worked really well. And the small expense of paying for your judge could actually be very quickly swallowed up by the waste of costs of having two legal teams sitting around at court all morning doing nothing. And so we started to use the private FDRs in that window of opportunity that was given to us when the court said, well, we'll list you now for an FDR. You have 3 months. And if in that 3 months you could find a private FDR judge and have your private FDR, so much the better. Well, that's simple. That's what you do if you're in proceedings. But why wait till you're in proceedings? Because it seems to me that very often what happens is that, and I find this in the papers that I get sent a set of papers, and they're perhaps double the size that I thought they would be. Because what's happened is the parties have had voluntary disclosure, perhaps as part of mediation, perhaps just as part of solicitor negotiation, and they've fallen out on a point of principle. And so the negotiations have broken down, and then somebody is issued and they've entered into the court proceedings. And that immediately triggers the court sending them the notice of first appointment saying, complete a questionnaire. So they think they'll do that, they'll ask some questions. And they'll get a new Form E. And the new Form E isn't quite the same as the voluntary Form E. And so they start asking questions, and you can feel the temperature. As you're reading the papers, you can feel the temperature rising. But actually what this all comes back to is the original point of principle that they stumbled on when they were in negotiation. And the example perhaps is the husband has inherited a cottage in Cornwall. He's got his inherited asset, and he's very keen to keep his inherited asset. And he says that that's what he wants to do in the negotiation or in the mediation. And the wife wants it sold, and she wants it sold, and she wants the value of it added into the assets to be shared between them to meet their needs. And the husband goes off to his solicitor, and he explains that he inherited this cottage from his granny, and that his granny had inherited it from her granny, and it's been in the family since forever, since it was very first built, and it's his, and it's his inherited asset, and the wife's done nothing at all to contribute towards it. And his solicitor says, well, of course it's an inherited asset, so that's not going to fall in to be considered as part of the sharing claim. And the wife goes to her solicitor, and she explains how there's this cottage in Cornwall, and in the early days, they used to rent it out and use the money that they got from it to make ends meet. And then as they got a little bit better off, they were able to put some money into renovating it. And then when they had children, it's where they used to go for every family holiday. It's part of the fabric of the family. But unfortunately, not affordable now. It's just going to have to be sold so we can have a decent house to live in. And her solicitor says, well, of course, you can't just ring fence an inherited asset if needs require it. And neither of them have been given bad advice. They've been given partial advice. They've been given the advice that supports what they want to hear. But now they can't make any further progress. And what they could do, rather than getting embroiled in a court process and raising the temperature on not just the cottage, but every other issue between them, is they could at that stage go for an early neutral evaluation. Within court proceedings, we'd call it a private FDR, but the effect is the same. You give all the information to a completely impartial judge, evaluator, whatever you want to call them. You can put your arguments to him or her. They can look at it in the round. So they're not now just focusing on the argument about the cottage, but they're looking, well, if we do retain the cottage, what does that mean? And maybe it's something which should be offered to the husband as an option. He can keep it, but he's not going to get a greater share of the other assets. It'll have to come as part of his share. And if he wants to have a bigger mortgage, then that's what he'll have to do. Or it might be that he's told it has to be sold. Or it might be that the wife is told that actually there's more than enough money to meet all her other needs, and that there's no reason why it shouldn't be excluded. And of course, that would have the advantage that the children would still be able to have their holidays there when they're staying with their father. But they're unlikely at this stage to be able to see those answers. And that's why the third party, the impartial judge, can give them that nudge, get the thing going again, push start the car so that rather than stalling and ending up in a ditch, carries on, hopefully, towards the settled, negotiated settlement that they were all looking for.
That sounds a wonderful way forward. Let me just make sure I've understood it. What you're suggesting is that increasingly FDRs, let's call them that for the moment, some form of an FDR, could be used as part of either the mediation process or some general negotiation process before proceedings have started. And what you're suggesting is that that might be a way to cut through that problem that we're all familiar with, where you've got partial advice coming from each side, which isn't wrong, it's just not taking the situation in the round.
Yes, and I think all I would add to that is the emphasis on the early neutral evaluation. That I think that there is a real opportunity, and in a sense, it's an opportunity which has been thrown up to us because as a result of what's happened over the last few months and the courts effectively closing down for a while, we've had to look at alternatives. And it seems to me that one of the opportunities that we should grasp from this is, I suspect that very often the alarm bells start ringing quite early when you see those points of principle, those points where things are going to start to stall. And if you can see them early on, why not try and get some impartial advice rather than sending the two parties off to their respective camps to start to build their armory, to start to think tactically as part of an adversarial process, which then leaves them entrenched, actually push them towards tackling the problem they've really got. What is this point of principle? Which is because they probably know that they've got there's going to be maintenance being paid for a few years while the wife reestablishes herself in work, that they're going to have particular housing needs and their housing needs are not dissimilar. That all of that basic groundwork has been done, but they've come up against some sort of stumbling block. And the earlier you deal with that on an impartial basis, the greater your chances are of getting the mediation, the negotiation, whatever it may be, back on track. And the later you leave it, the greater chance you have of the two parties becoming entrenched.
So is the FDR the only way to achieve that, to get an early neutral evaluation?
It's not the only way. And you could, for example, ask somebody to give you a written opinion on a particular problem. For example, my problem about the inherited asset or whatever it may be. The problem with that is that one of the things that we found in court is that it is very helpful to actually have everybody there with the judge able to look at them, get a better idea perhaps of what their particular concerns and anxieties and desires are, and to be able to look them in the eye and say, I really think this is the best answer. And for them to have some opportunity to come back to you. And I think what I would say about that is that there may be other ways of doing it, but every now and again, we come up with something which really works. And the FDR really works. And so I don't think we need to reinvent the wheel. I think all we have to do is attach the wheel to the vehicle earlier on so that it can move along more smoothly.
Well, how would you see that interacting with mediation, for example?
Well, I think I'd come back to my holiday cottage.
Granny's cottage, I'm going to call it.
Granny's cottage, the inherited asset, whatever it might be. That point where in mediation, you are perhaps not giving legal advice, but trying to give legal information. And you can see, I'm not a mediator, but I suspect you can see that the information you're giving is being registered and read by one side as, that's good, I can keep Granny's cottage. And on the other side as, that's good, so it's going to have to go towards meeting needs. And you also know, because you've advised your clients that they should seek legal advice as well as part of the mediation process, that the point at which they go running off to see their solicitor and then come back to you, you can tell they've now had conflicting advice. And like I say, I'm not a mediator, but certainly my experience from reading solicitors' correspondence and seeing what's happened within solicitor negotiation and seeing sometimes the memorandum from mediation, you can see the point at which it's happened. And I feel a little bit like those judges who years ago were saying, but the answer is blindingly obvious. Why didn't somebody let me get in and give them the answer earlier on? It's exactly the same thing. The point at which the problem starts to emerge, why not tackle it quickly? Because if you don't, and I think this is my point about what happens with the court proceedings, you issue your Form A, the court sends out the thing saying we need a chronology, we need a statement of issues, and we need a questionnaire. And the chronology maybe not so much, but the statement of issues invites you to say, what are we falling out over? Not what do we agree about? The questionnaire invites you to start to look for all the things that you're not quite certain about. Whereas you might just have shrugged your shoulders and gone, actually, he's not a non-discloser. He seems to have got himself in a bit of a muddle about where he pays what from, but I'm not bothered about that. I want to move on. I want to try and find a solution. And as well as that, quite early on in court proceedings, people have to start to think tactically. They have to start to think about how they're going to set themselves up for the fight. I'm suggesting that people get in before the fight has even started, before they've entered the ring, and actually say, we can see this coming. Let's do something about it early on. Let's get some early, neutral, impartial advice.
And I could see two useful points at which mediators might need to use that idea. And one is when we meet people for the assessment meeting, what is often known as the MIAMS meeting, when we, if it doesn't go well, we're going to be signing a court form. And that this might be one option that needs to be added to our little range of options, which starts at where you can sit around the kitchen table and runs all the way up to court. Now, mediators have an enormous amount of information to pass on in that relatively short meeting. So what would you suggest that they say to somebody to make sure that they know that this kind of early neutral evaluation is an option?
I think it would be to explain that this might not be a completely smooth path through to settlement. It might be that we come across issues on which we can't agree. Some of that might just be fundamental disagreement. There's no point of principle, you just don't agree at all. And it becomes apparent that this is not going to be suitable for mediation or negotiation. They're going to have to get somebody to tell them the answer. But some of those disagreements will be disagreements where it's quite finely balanced, it's quite nuanced. Nobody's right or wrong, but they've got to find a way through. And if they can't find a way through themselves, they might want to consider not having something imposed on them, but being given the opportunity of being given that little warning about what might happen if they don't try and settle. And I think I would also be pointing out to them the advantage of costs very early on. I think that's the other thing I would be saying to them is, don't worry that this might cost us a little bit of money. Don't please get the impression that if we have to go to a barrister or a solicitor to get this indication, it's going to cost you a lot of money. I would emphasize the fact that if we stall like that and we can get an early evaluation, that might actually save time and costs in the longer run.
It might be helpful, and I do appreciate this might be how long is a piece of string question, for mediators to have an idea about what sort of range of costs. So I'm not asking for an average, but what sort of level do costs start at for this sort of thing?
I'm going to give you a barrister's answer to that, which you'd have to ask my clerks. I really don't know, other than I'm pretty certain it's not as expensive as people think. Apart from anything else, if you're doing it very early on, and if my clerks were rung up and told, there's no Form Z, there's a substantial asset schedule which sets out what the assets are. There's maybe a couple of pages of summary of what the case is. They'd like to come for an early neutral evaluation. I would hope that under those circumstances, my clerks are not going to say, well, Mr. Lazarides has a fee of, and I'm afraid I really don't know what my fee is, but I know it's on the website if anybody wants to look. That's what he'll be charging, because I won't have done the preliminary reading of the sort of amount that you might get if you end up in exactly the situation I've been saying, where you've allowed all the other issues to become part of the stew as well. And the other thing I would say, which I don't think this has been taken up yet, but I would think it's an option that people should be looking at. If I was phoning up barristers' chambers and asking about this, I'd be asking as well about the more junior members of chambers who possibly have more experience of the sort of case that you're going to them with, and asking what they would charge to do this sort of work. And I suspect you'd get quite competitive answers on that.
And that's really, I think that's a really useful idea, because I know that there'll be a number of mediators who will be aware of some forms of early neutral evaluation where there's a fixed starting fee of, let's say, £5,000, which for most mediators will mean that their clients are simply not going to take that up.
I'm almost certain that my fee is nothing like that much. It's a little more than half of that, but I think it's around about £3,500 for a private FDR. And I'm certain that more junior members of my chambers, who I'm sure would be only too interested in getting into this sort of work, and would be able to do it very, very well, because they are the ones who are actually at the coalface, week in, week out, seeing what the judges are doing with these cases.
So I think that's an important point. So what we're saying is, match up the expertise of the person doing the hearing, the private FDR, with the level of the case, not just on the basis of costs, but also because somebody who would be a junior barrister doing that sort of case will have a much better understanding of what would actually happen in court.
Yes, I would struggle now, without doing a certain amount of research, to do a case which involved looking at people whose substantial amounts of their income are coming from benefits, because I'm out of touch with that. That doesn't mean that just because a substantial amount of people's income was coming from benefits, they couldn't both afford and benefit from an early neutral evaluation as a way of getting them over the line. They just need to get it from somebody whose bread and butter still involves cases of that sort of wealth. Okay.
I'm aware we haven't talked about arbitration yet, and I'm going to come back to that. But while we're thinking about early neutral evaluation and how a mediator might be directing somebody, the first bit that I'd thought of was, okay, people during the assessment need to maybe include that in their spectrum of things that somebody might be interested in thinking about. The other, fairly obviously, is the situation you've described, and Granny's Cottage has come up. And they've both had different advice, very different advice from their solicitors. And, why pay a solicitor to give you advice if you're not going to take it? So it might be quite difficult for the mediator to say, well, you're going to have to put that to one side and just think about this in the context of finding something, proposals between you. How would mediators go about setting up, helping their clients to approach somebody for a private FDR? What sort of things should they be telling the clients to think about?
I think they go back to their solicitor and ask their solicitor to talk to the other side and get it set up, to instruct a member of the bar or another solicitor to conduct the hearing for them. There is no real formal process. If you were already within court proceedings, you would have to get a direction adjourning your court proceedings so you could step outside the court proceedings to have your private FDR. But if you're doing this in the way that I'm suggesting, as really genuinely early neutral evaluation, all you need to do is instruct the barristers' chambers. And if you can find a barrister who will do it on direct access, possibly don't even have to do it through your solicitors. I think the important thing is that you do it at a stage when there is enough information for that person to be able to give you a properly informed evaluation. So you would need to do it at the stage where you have sufficient financial disclosure. And as I say, I don't think that needs to be in any particular form, but you need enough financial disclosure, and you would need enough information, possibly in the form of either oral or written submissions, probably oral submissions, because I think it goes better with the idea that this is supposed to be a real balancing of the arguments on the day. So that they have all the information, so they make an informed decision. And it should be not just an informed decision about Granny's Cottage. They would need to know what the full background is. They would need to know what the totality of the wealth is, what the incomes are that are going to support this family going forward. So they're not just being asked to say what the law is on inherited assets, but how does the law apply to the facts of this case? But it would be, I think, probably to go back to the solicitors that, I'm going to say this slightly crudely, go back to the solicitors who put them in this mess in the first place as a result of the advice they've given, and say, okay, we don't want to know what the problem is. We don't want to know what the solution is. Can we instruct somebody to give us the solution? And if they're told that that's going to be very expensive, I suggest they ask their solicitor to get some costs to see how expensive it will be, because it needs to be expensive.
And what sort of process is it? I mean, what does it involve? Is there what degree of formality is involved? How are people going to need to be prepped for that?
You need prep before the hearing, if it's going to be done as a hearing, if it's going to be done in the barrister's chambers or solicitors' offices. You would need to make sure that you've got the disclosure and it's set out in a way that everybody can understand it, and that your judge looking at it for the first time can get their head around it. I think it's helpful if they have some sort of written note of the submissions that are likely to be made, the arguments on either side. I think it is helpful, if not essential, to actually have the proposals that each side are making, so they can see exactly what both sides are saying. If you like, their offers, their positions set out. Traditionally, we've simply adopted the same model as the court, which is to ask everybody to come an hour or so before they actually want to see their judge, so they can do some negotiation. I'm not sure that actually is particularly necessary with the private FDR. That time at court generally is used trying to iron out the small differences, or actually what it's really used as is the rather unattractive sight of two barristers puffing their chests up in front of each other, explaining why they're right and the other side are wrong. So I think what you do is you get to the barristers' chambers in time to be settled down, brought your cup of coffee, feel comfortable in your environment. This hopefully doesn't feel like going to court. It doesn't feel like sitting in the dentist waiting room. You're in a comfortable room with your solicitor who you know, possibly just with your solicitors. No reason why the solicitors shouldn't be doing this themselves, but if they've instructed a barrister, then a barrister who you become familiar with hopefully as well, you feel comfortable. When I'm a private FDR judge, I will go and knock on the door of the respective parties' rooms and introduce myself so that they know who I am and what I look like before they come in more formally to see me. When everybody's ready, they come in and see me. And there have been occasions when they don't actually come in and see me, because merely getting to the building together, all being in the same place, with their legal teams on either side, with the advice they've been given, they decide they will do a little bit more negotiation, and then a little bit more and a little bit more. And I get told sometime around about lunchtime I'm not going to be needed because they've managed to resolve everything. But more normally, people will come in and see me. They'll set out their case. I confess, normally by the time they've come in to see me, I've started to form a pretty good view of what I think the answer is. Having said that, that's not set in stone, and I will listen to what people have to say, because very often people put their argument better, or when I hear it and look at everybody around the table, I begin to see it in a slightly different way. I will then normally send them out of my room for half an hour or so I can get my thoughts in order, have them back and tell them what I think the answer is. And sometimes that is absolutely unequivocal. This is the answer. It's blindingly obvious. Of course, Granny's cottage will have to be sold. What on earth are you ever thinking otherwise? Although I tend not to put it quite as bluntly as that. Sometimes it's slightly more nuanced. But I try to give the answer in a way which means that the path is now clear for negotiation. But I also make it absolutely clear that if those negotiations stall again, if my indication isn't good enough at that stage, come back and see me again. And I have on occasion gone and knocked on doors and said, how are you getting on? It sounds like you're getting stuck. Come back in and see me. And I don't know what the actual facts and figures are on these, but anecdotally, certainly what we're told is that these hearings are very successful. They are more successful than the early court proceedings were, and that was pretty good. They're certainly more successful than the current court proceedings are.
And your sense is that the earlier they happen, the more successful they can be for people, and that's obviously particularly relevant to mediation.
My feeling is that there are too many cases that I get that are sent to me when I look at it and think, why on earth did we allow all of this paperwork to be generated, all of this correspondence to be generated? You can see the turning point. You can see the point at which the very helpful correspondence that's all about how, of course, my client is looking for a settlement and doesn't want to engage in these proceedings. That all we want is a timetable, how that very quickly turns into a battle on all sorts of fronts. And it's frustrating. As I say, it's particularly frustrating when you have the voluntary form E that was produced as part of mediation, as part of negotiation, and then months later the formal forms E that have been produced. And you look at it and you think, why? Because what you're really arguing about is, can I keep the cottage or not? The rest of it is going to fall into place. But you've come up against a point of principle for which there is no absolute right or wrong answer. And rather looking at how the discretion might be used, you've fought a battle. And if you can not engage in the war, you've got a much better chance of settling. Once you've started to once you've started to dig your trenches, you're going to have a fight. Don't do it. Get an indication earlier on.
And that all sounds very positive, and as though this is a tool that mediators might be able to use. Now, the other thing we haven't talked about yet is arbitration. And I know you're a qualified and experienced arbitrator. So can you say, bearing in mind those two things that mediators are going to need to be able to do, they're going to need to be able to explain it sufficiently during an assessment meeting, and particularly if anybody expresses particular interest in it. And they're also going to need to be able to say to people who are getting stuck, and we'd all rather they didn't end up in court and spend lots of money doing that, it might be necessary to point them in the direction of arbitration instead.
Yeah. I'm going to do the second bit first. So pointing them in the direction of arbitration, when might you do it? Why might you do it? Let us say that you've tried my trick of the early neutral evaluation and you're still stuck. The poor husband left the hearing in tears at the thought that Granny's cottage was going to have to be sold, and simply couldn't come to terms with the idea that that was what was going to happen. So the mediation has now broken down. He's not going to be able to come around to that way of thinking. So what can you do? What can you advise next? And of course, one option is to go back to your solicitor, fill in the Form A, issue proceedings, and watch the court lose the Form A, fail to list a first appointment in the local court, adjourn the first appointment when they realise they don't have a judge available, have an argument about the valuations because they're different now to what they were in your Form E, have an argument about the questionnaires, have an argument about anything you can think to have an argument about, and then watch the court fail to list the FDR at a date when everybody can manage, and then watch the court as they fail to show any sort of flexibility as you try and deal with that. And anyway, you know your FDR isn't going to be successful because you've tried that already and you got nowhere with it at all. And you could do all of that at some fairly substantial expense and emotional turmoil. Or what you could do is you could say, well, we've just had the early neutral evaluation. We've just prepared everything for presentation to a judge. We tried to go down the route of that being a judge who was only going to give an indication, nothing binding, just point us in the right direction. We tried that and it didn't work. What we actually need now is to put all of this in front of a judge who can give us a binding determination on this issue. But why don't we just do it with the material we've just gathered together for the early neutral evaluation we've just had? We might need to have possibly more formal statements actually setting out everybody's case. So what if it was we were in court proceedings would be the Section 25 statements dealing with each of the issues. But let's not waste any more time. We've got the disclosure together. We know what the argument is. If it was ready to put in front of an early neutral evaluation, why isn't it ready to be put in front of a judge for arbitration? And so it could be a matter of just a few weeks after the early neutral evaluation, you could find yourself going in front of an arbitrator. And now your first point, what is arbitration? What does it look and smell like? Well, the big difference between the arbitration and the early neutral evaluation or private FDR that we've been talking about is that it is binding. You sign up to something where you say, we will go to arbitration and we will do what the arbitrator says. Now, I say it's binding. It has to be, the arbitrator's award has to be turned into an order by the court, but the courts have made it pretty clear that they are very unlikely not to be making those arbitration awards into orders. And the courts have also quite recently made it very clear that it is going to be almost impossible to appeal those decisions. Now, some people may see that as a disadvantage. Well, I don't want to go to arbitration, I won't be able to appeal. I think actually it's an advantage. You know that this is final. You're going to go to your arbitration. You're not going to be messed around afterwards by somebody who decides they still don't like what the judge has to say, still can't come to terms with the fact that Granny's cottage might be sold. You've now been told by the arbitrator it's going to happen. So you're signing up to something which is perhaps not what you were hoping when you first went into mediation, because this is a decision which is going to be taken out of your hands. But maybe that's the stage you've got to now. Maybe that's the only way of getting some sort of resolution. How it's done, though, is, again, much more flexible than if you're in the court process. If you're in the court process, we know that, again, you're going to have to go to that scary, rather intimidating building where you will be put in front of a judge who, it might be that one or other of your solicitors or barristers or somebody has had some experience of. It might not. It might be a deputy that nobody's ever heard of, and nobody's ever had any experience of. It might be somebody who has some real background in family law, but it might not. It might be somebody who spends Monday doing bankruptcies, Tuesday doing repossessions, Wednesday doing Children Act matters, and Thursdays doing financial remedies. And they don't really like Thursdays, and if they can get out of them, they do, because it's the area where they feel least competent and least comfortable. And it's going to involve probably a lot of waiting around as the judge has to take on other hearings. And then eventually you get in, and there is a determined formal process which is going to have to be followed. And that's going to involve you being cross-examined. And that's going to involve your spouse being cross-examined. And that's probably going to leave both of you leaving the court process with a slightly bad feeling in your mouth, actually. And it's certainly not going to make the next, let's say, for example, contact visit any easier, where you are handing the children over to the person who was accusing you of all sorts of horrible things when you were in court. Arbitration doesn't have to be like that. It can be completely adversarial, but it doesn't have to be. You can decide that actually you want to do your arbitration and you want to do it on paper only, so you'll never go and see the arbitrator at all. You can decide you'd like it done on submissions only, so very like your early neutral evaluation or private FDR was done, where your judge will listen to all the salient points. My experience is that where arbitrations are done like that, the judge takes a very much more proactive role and very often asks many more questions and will send people out and they'll come back with further instructions for him. Or you could decide that you'll just have cross-examination on a particular issue. So if there's an issue about housing, for example, you will have cross-examination, but only on why it is these 3 or 4 houses wouldn't be suitable to meet your needs. Or you might have cross-examination, not of either of the parties, but of the expert who's said what income the husband will be able to get from his business. And so you will at least leave with your relationship, whatever that might be at that stage, intact and certainly not made any worse by the process. And you should also get your decision from your arbitrator reasonably quickly. You're unlikely to carry on getting many instructions as an arbitrator if you keep people waiting for the sorts of lengths of time that some of the judges, and I don't blame them for this, they do it as a result of the volume of work that's being dumped on them. But the sort of length of time that you have to wait for your judgment, that shouldn't happen in arbitration. It's not always going to be less bruising. I have done arbitrations both as arbitrator and as counsel, where they have looked and smelt in many ways very like a court process. but I have also done them where they have just been dealt with by submission, where they have been dealt with where we've just cross-examined an expert. And generally my experience of them as counsel is that my client leaves the process feeling very much happier, not because they've won or lost, but because actually it wasn't the same bruising experience that it might have been. And they know what the answer is. And they can put it all behind them now and get on with their lives. And it's happened much, much quicker. And a question you were asking earlier about cost, I have absolutely no doubt in my mind at all that the speed with which you can get to arbitration is always going to mean that whatever the cost of your arbitrator, you have saved quite substantially in terms of financially, in terms of cost. And because of the way the process works, you will almost certainly have saved in terms of emotional cost as well.
And I quite often have clients where I'm talking to them about arbitration. I'm always slightly surprised by how little people know about it, and how they don't jump at it because of speed and so on. But many of them are put off by the idea that they are going to have to pay the arbitrator. That's the bit that slightly frightens them. What should I be saying to them to explain why, as you've already said, you have no doubt that the cost of the arbitrator will be absolutely met by the savings that you're going to have? Because if they're just waiting, what is it about just waiting for the court to get round to doing it that generates cost?
Okay, so you issue your Form A, you're going to go through the court process, because I'm assuming now that we've got to the stage where it's one or the other. It's either court or arbitration. The negotiation, the mediation, the private FDR, whatever it might be, we've gone beyond that stage now. So you issue your Form A. That then gives you a timetable. And people said, well, of course, we want to do this because we want to be able to impose the court's timetable. The court timetable really isn't that quick. So while you're waiting for the court timetable, while you're waiting to be listed for your first appointment, and then when you're waiting after that to be listed for your FDR, because if you've had an early neutral evaluation, the court may very well turn around and say, no, sorry, you didn't do it here at my court, and I know FDR's work. I'm going to have you in for an FDR, if you don't mind. So while you're waiting, you waited a couple of months to get to the first appointment, you've now got to wait another 3-4 months to get to your FDR. Let's take, for example, what are we doing now about the interim measures? What's happening while we now have this fight? Because we're not getting on very well anymore. We've gone to court now. We've found that we've started to ask people itchy questions. We've started to do things where we've started to fan the flames. We're not getting on as well. So I want to know what's going to happen about the interim position. So my solicitor writes a letter about it, and his solicitor writes me a letter back about it, and we bounce those backwards and forwards, and somebody said, well, we're not getting anywhere, we're going to have to issue now a maintenance pending suit application. My experience is that most maintenance pending suit applications are resolved before they go to court, but we've still had the correspondence going backwards and forwards about it. We've still issued the application. We've still spent thousands of pounds getting that far. We've probably spent half of the arbitrator's costs, half of the arbitrator's fees getting to that stage. And then we start falling about all sorts of other bits and pieces along the way as well. We don't like the questionnaires. We're going to have an argument about those. And we don't like the answers we've got. And we're going to have an argument about that. And the Forms E now are 6 months old, and lots have been happening in the housing market in the last 6 months. So we better update all our valuations. And we better update all our disclosure. And there's a great long list, a great shopping list of what you do when you update disclosure. So you have to produce the 6 months worth of bank statements and the 6 months worth of credit card statements and all the rest of it. And you've just spent the other half of the arbitrator's fee. Whereas if you go back to what I said before, you've just finished your early neutral evaluation, you've got all your disclosure together, you're ready to go. Go now, press the button, and you're there. And I'm sure I could think of many, many more creative ways that people could think of generating costs and spending money. And I'm not critical being critical in this, of the solicitors in these circumstances. It's rather the way of things that if you start to fall out, and the only way of dealing with things is through correspondence, it's in the nature of things then that starts to generate costs, and the court process, if you like, creates the vacuum into which that falls, because it creates the delay. And arbitration is a great way of avoiding that delay.
Okay, and that's really useful. Just coming back to that little first bit of my question about arbitration, a time-pressed mediator wants to make sure that the person in front of them understands that arbitration is an alternative to litigation. Mm-hmm. What should they be saying?
Well, first of all, they start from where you did with the question. It's an alternative to litigation. It's not an alternative to mediation. It's not an alternative to negotiation. It's an alternative to, at the point when they are looking down the barrel of the gun and they are looking like they're going to be going to court. That's the point when they look at arbitration. And what they should be saying is that they should look at this alternative, which I believe in the long run, despite the cost of the arbitrator, is likely to be cheaper, quicker, but it's a bespoke option. It will deal with their problems, their dispute, not be the off-the-peg version that could deal with all sorts of disputes, and will deal with theirs along the way, but won't give them necessarily the tailored answer that they want.
And I think that's the thing as a mediator who I spend my professional life trying to give couples options and trying to make sure that they are in charge of their own decision making, trying to give them the tools that they need to be in charge of their own decision making. That's one of the things I like about arbitration, is that they can say, well, we'll do it on paper if we want to. They can say, well, we'll do it, next Wednesday, because Wednesday is the day when Auntie Alice can come down and look after the children, instead of being told that they've got to go to court on a particular day and then find out when they get there that they might not get a decision after all.
I think you're right. And I think possibly one of the ways I would try and sell it to people is, once you go into the court process, you really have lost control. If you go into the arbitration process, you've lost control of the final decision, but you've kept some control of the process. And
that's a good distinction to be making, because obviously in mediation, our goal is to give them control over all of it. Together.
And the only thing I think I might say about that, but I don't think this would be for your hard-pressed arbitrator at the first meeting.
Mediator, hard-pressed mediator.
Mediator, sorry, thank you. Your hard-pressed mediator at the first meeting is just be a little bit cautious, if you want to keep control like that, about how quickly, if you do decide to go down the route of arbitration, how quickly you sign the ARB1 FS, the form that commits you to arbitration. Because once you've done that and appointed your arbitrator, you have lost a certain amount of control. The arbitrator now could say to you, actually, as happened to me in a case, we'd signed up to arbitration believing we were going to have a full hearing with evidence. The arbitrator suggested perhaps it could all be dealt with on paper. The other side leapt at the opportunity, and the arbitrator said, well, that's what I'm going to do, despite our objection to it. Now, that could have been avoided, because actually what could have happened is that we could have discussed that with the other side and found that if we didn't agree on what the process was going to be, we weren't going to sign the ARB1. Having agreed what we were going to do, we could record that agreement as part of the ARB1. The other thing we could have done is we could have had an earlier meeting with the arbitrator, sounded him out, found out what she was going to do about an issue like this. But I think you're unlikely to get those sort of roguish decisions and outcomes, because actually those of us who do arbitration want to make the process work. And I'd quite like more of this sort of work. I enjoy being an arbitrator, and I don't want people going off saying, well, I wouldn't use Lazarides because actually he seems to have some sort of little Mussolini complex, and the moment he was given the power, once we filled in the ARB1, that was it. He then did we had to jump to his tune. That's not the way it should be. I want, if I can, as an arbitrator, to make sure that the process is as comfortable as it can be. It's not going to be as good as being able to come up with a solution without going to a third party to impose it on you, but it can be a pretty good second best.
Okay, and that's a really useful, perhaps another tool to be put in our back pockets to point people who have nearly but not quite managed to retain that control and make the decision themselves. Now, it's very interesting listening to somebody who has daily experience of courts and the litigation process, talking about it in such negative terms. Is that okay for me to say?
Yes.
Okay.
I should explain where I'm being negative. It is not because I think that the judges are incompetent or unable to do this. I just think if you give people too big a workload, the cracks will start to appear, and that's, I think, what is happening with the courts at the moment.
Well, that's sort of where I mean, you know, I think lots of us with any experience in this area perceive a court system in crisis, and as you say, underfunding, overwork, and far too many people being directed towards litigation, one way or another. So, has your experience of the last 12 months been that has been getting worse, and what are your expectations for the next 12 months?
Okay. Before COVID, if we're dealing with that, not so much 12 months, but maybe 6 months or however it is since March. Before COVID, there was no doubt at all there was increasing take-up of private FDRs, because what people were told was you can have a court FDR in 4 months. They were told that at the end of the first appointment, where they'd had their first taste of the inefficiency and the struggle that the court was having to deal with their case. And so they did have the court timetable in place, imposing something on them. And they didn't much fancy what the court was going to impose on them. So they were taking up the offer, the proposal of the private FDR, or they were opting out of it altogether and going to arbitration. Not so much. It was really the private FDRs over the last, before COVID, 18 months before, and we were seeing it spreading, if I can put it crudely like this, sort of down the food chain. So it was no longer just the very wealthy, not just the big asset cases, but it was being used as a tool across the board as a way of resolving issues. And it was working very well. And then COVID came along, and the courts were sending out guidance and protocols and begging letters almost, saying, we can't cope, we can't deal with this. Your hearing is just going to be adjourned off. It's going to be adjourned off forever. We have no idea when we're going to be able to deal with this. Can we please, please, please urge you to go to a private FDR or arbitration, or consider some alternative dispute resolution, because we can't cope. And I think as a profession, we all thought, well, this is bound to happen, isn't it? This is what will happen. Our diaries will fill up as people look for private FDRs for arbitration to resolve their issues as quickly and as efficiently as they can. And it's very difficult to know why that didn't happen. I think it might have been partly just fear and panic. People didn't really know what was happening. Somebody had just told them they couldn't go into work anymore. And it wasn't because their job had disappeared, because the business had collapsed. It's because somebody just told them you can't go into work because it's not safe. And there was no housing market. The housing market was just closed down completely. So there was a fear and uncertainty, and that may have resulted in people not wanting to start looking for how they could resolve issues, because actually their issues now went beyond the breakdown of their marriage. Their issues went to, I just don't understand what's happening, and it's a bit scary. I think there was another thing which started to come into play though, which was that people looked at the short-term tactical advantage of the fact that courts couldn't deal with things quickly. So for example, let's take a case of a wife and mother and 2 or 3 children who knows that as part of resolving the financial claims, the house that she's living in with the children will have to be sold, and they're going to have to move to a smaller, less desirable house. And that will happen as soon as finances are resolved. And the court's telling them that if you don't do it yourself, then we're going to have a hearing in 3 months' time. Except they're not saying that anymore. The court's saying, if you can't resolve it yourself, we've no idea when we're going to be able to get around to dealing with it. So why now does that wife and mother rush towards a solution, if actually the solution means she's going to lose her home, and the alternative is she'll be in a home till the end of the summer at the very earliest, and possibly beyond that? Or the money maker, I'm going to say the husband because in so many cases it is the husband who's just seen his income drop, but he's been told by his solicitor that actually the amount that he pays in maintenance is likely to be based on his earnings over the last couple of years. And he's thinking, but I'm not going to earn that much again. That's not going to work for me at all. And so what he does is he says, well, I'm not going to rush to a private FDR. I'm not going to rush to arbitration, because by doing that, I bring around a solution based on my income over the last 12 months. If I wait a little bit, my income goes down and I don't have my income assessed on money that I'm not making. It's assessed on what my actual income is now. And so people found a tactical advantage in delay. And that worked for a while. But I think increasingly, as people come to realize that this is not an issue which is going to go away, there is no quick fix to COVID, there is no quick fix to the economy, and they don't really like the uncertainty of not knowing what the final resolution of their financial proceedings are going to be, people are now coming back to looking for solutions. They are coming back to private FDRs, and they are coming back now in increasing numbers to arbitration, because the courts can't cope. And I don't know necessarily if I'm seeing more private FDRs than I was seeing before, but I'm certainly starting to see take up in arbitration in the way that I think I've been hoping for months, if not years.
Okay, so Marcus, you've talked about the fact that you're not sure whether or not the uptake of arbitration and early neutral evaluation is going to go up post-COVID or stay at its relatively low levels?
I think that the initial reluctance, and I don't know, as I say, whether that was people looking for tactical advantage or people just running scared. I really don't know. And I have some sympathy with those people who are running scared. Getting divorced is never going to be good. Getting divorced and launching yourself into an increasingly uncertain world is always going to make things worse. I don't know which of those two it was, but having seen an initial drop-off in the number of private FDRs in arbitration, there has certainly now been an increasing uptake again. I say not so much an increasing uptake in the private FDRs. I think that's just come back to the sort of level we were at before, but I have certainly seen more arbitrations, both where I've been invited to be counsel and as arbitrator, in a way which I've been hoping maybe would happen for some time.
Okay, so maybe this is the dawn of a new age in that respect.
You know me well enough to know that I'm a natural pessimist. I'm not going to agree to that, but yeah, I would hope so.
So the other question was then about that business about economic uncertainty. When you talked about fear generally in relation to divorce, but at the moment, lots of people are very frightened about a future which looks unlike anything they've seen before. And certainly the mediators that I know who are doing financial mediations quite often are talking about the fact that it's going quite well, but that then comes a point where people say, we just don't know enough about the future at the moment to start making any decisions. So how do you feel early neutral evaluation and arbitration can fit into that issue?
There is no doubt it is a lot more difficult for us to advise our clients at the moment, because what we really want is absolute certainty. We want to know exactly what everything's worth. We want to know it's still going to be worth exactly the same amount further down the line. We want to know exactly what everybody's earning and that they're going to carry on earning exactly the same amount, and what the costs of the children are going to be, and the fact that the children are actually going to be at school, so everybody's going to be able to carry on working and all the rest of it. And the more certainty there is in the factual matrix, the more authoritatively and definitively we can give advice. And if you take away that certainty, it starts to get more difficult for us. That was the same pre-COVID. As soon as you started to enter into anything where there was uncertainty, what was the business going to be worth? What were the bonuses going to be in the future? When would a wife be likely to be able to return to work? All of those things. The more uncertainty, the more difficult it is to advise. But I think what we can't do is to carry on going, well, there's so much uncertainty at the moment, we're just not going to advise at all. Because that might have been all right in March, when we were first locked down and we thought this is going to carry on, it'll all be over by the summer, or it'll all be over, we're getting back and we know exactly what work's going to look like. Well, that's not going to happen. And our clients can't be expected just to put their lives on hold, because economic uncertainty has made our jobs more difficult. They may decide that there's so much uncertainty they don't want to create more uncertainty by getting divorced, but I'm presuming they've got beyond that stage now, that actually they've launched into the divorce, and unfortunately they've launched into the divorce in these very uncertain times. And so we have to do everything we can to make them aware of the options which are available, and where there is flexibility in the law, in the sort of orders that can be made that allow for that uncertainty. So the obvious ones, we know that periodical payments, that maintenance can be varied. And so if somebody is very worried, very anxious about what their income might be in the future, then we can either make an order which is absolutely affordable now at the very bottom of their earnings, safe in the knowledge that if their income goes up, we'll vary it upwards. Or alternatively, we can try and pitch it just a little bit higher, because everybody thinks actually reality is we're getting back to work now, we're starting to see our income go back up. Let's be a little bit more confident about that. But always knowing it can be varied, and if need be, recording in the order that the order was made in these times when the husband's income or the wife's income was only X, and that it's agreed that they will come back and consider variation in X months' time, or whatever it might be. There is similar sort of flexibility potentially in the sort of lump sum orders that can be made. We have lump sums by installments. There is some flexibility and some ability to vary those. Or maybe we're dealing much more with percentages, so that we can't give somebody the absolute certainty of knowing what they're going out with in their pocket to go and buy their new home. They're going to get a percentage of the proceeds of sale of the house. And maybe we have to start to look at those orders which the court can make, the orders in relation to a husband's business or a family business. So what do we do now about dividing this up? Everybody wants to keep it going, so we're not going to sell it and just divide it up as an asset. How do we deal with it? Well, maybe you can't buy somebody out anymore because the value of that business is too uncertain. They have to carry that uncertainty with them. They have to have some shares in that business as well. Whatever it may be, we have to start to look and think more creatively around ways that try to deal with the uncertainty by giving flexibility in the order and the arrangements that are made. And that might feel like not quite the same degree of finality. It might not be quite so easy in these times to come up with the absolute clean break solution that we would all like. It might be that has to go on hold for a few months or years until things have settled down, and then you can look at the agreement, the order that you had, and see whether or not you can now buy out, capitalize the claims, whatever it might be. But we have to look at what we've got, the tools that are available to us, and think as creatively as we can around them. And this, of course, is another reason why we should be going to arbitration. Because if you go to arbitration, or for that matter, to your early neutral evaluator on a private basis, they have more time to try to help to work towards the creative alternative. And the hard-pressed judge at a final hearing, faced with all this uncertainty, knowing that actually whatever decision he makes might be appealed, and he might be ridiculed by the next judge up as they issue a judgment that condemns him for being so foolish, comes up with the simple solution: just sell everything and divide it all. And nobody wants that. Nobody wants that. They wanted to try and keep the family home for a few more years until the children were left school or whatever it might be. But the judge can't deal with the complexity of it given the uncertainty, and so he says sell it all. Your arbitrator is much more likely to be prepared to work with you to try and come up with a determination, an award which sees the parties doing what they want, and could even be told he's got to.
And
One parties have agreed is the house is not to be sold. So now, arbitrator, come up with a decision, given that that's your starting point. Your starting point isn't the completely clean slate. But they have more time, and it's part of the job. If you're an arbitrator, you know the parties have come to arbitration because they want that flexibility. They want that little bit more creativity, imagination, and thought put into their final award, if it's possible.
And am I right in thinking that arbitrators are required to answer the questions that are put to them, rather than to come up with their own, this is what I think should happen?
Yes. So, for example, it is possible to have an arbitration where you are told that the capital division has been agreed. You are only being asked to arbitrate on maintenance. Or it's been agreed that these two properties will be retained. You've got to divide up the rest of the savings and decide what should happen about maintenance.
So again, I mean, fairly obviously, there are a number of mediated awards that fit together like a jigsaw puzzle, and if you take one out, the rest of it falls apart. But sometimes you will get a situation in which clients have agreed, they're agreed, they've created, in a way, a sort of independent jigsaw, but there's this one piece that they can't agree on. So you could say to them, well, you can have your summary proposals, and it will say this last bit has not been, you haven't got joint proposals in relation to this last bit, so you're going to go and arbitrate on that, but the rest of it can stay as you've decided it.
Yes, and that last bit that you might be arbitrating on, and this doesn't really answer your question about economic uncertainty, but I have done an arbitration as arbitrator where actually the dispute was about the chattels. Now, they were fairly substantial, and that's why it was worth their while spending the money on having arbitration, but everything else had been decided. I wasn't asked to determine who should have what from the capital. They just couldn't decide how to divide up jewellery, cars, and an art collection. Now, I suspect, I'm not absolutely certain about this, but I suspect I'm asked, when I'm given the ARB1, I'm asked whether or not I want to accept the arbitration. It is possible that if you gave me a jigsaw that, as you said, had been mostly put together, but it's the last few pieces that haven't fallen into place, I might look at the jigsaw puzzle that you've given me and think, well, no, you haven't actually done the jigsaw puzzle at all, because that blue stuff that you've put in the sky is actually clearly C. And I really don't want any part of this dog's dinner that you've put together. And I personally could say, no, I'm not accepting this arbitration. But that doesn't mean you wouldn't find somebody else who would. And I have to confess that actually I'd be much more tempted to try and sort out your dog's dinner than to refuse it. But I couldn't rearrange your jigsaw puzzle if you told me not to.
And again, that might be something that's really quite appealing to clients, and also will help mediators, again, provide clients with a different range of tools.
Yes.
I'm just having a look at all of the questions that I'd prepared in advance, and I think, I believe that we've talked about pretty much everything that I especially wanted to ask you about. Is there anything else that you wanted to say in relation to arbitration? And
it's not necessarily something else. It's really just to emphasise what I'd quite like to conclude on, which I'd like to suggest two possible route maps. And the one is mediation. The mediation stalls. At an early stage, you go to early neutral evaluation. That hasn't helped. Clear that you're not going to be able to enter back into the mediation because actually the dispute now is getting worse rather than better, unfortunately. You go to arbitration and you're done and dusted. And you haven't at any point completely lost control of the process. Or alternatively, when your mediation stalls, you issue a Form A, you get caught in the slough of despond, which is the court process. And many, many, many months later, you get a judgment that nobody likes, which somebody decides to appeal. And with a lot less money, with deep dissatisfaction, and a loathing now of your ex-spouse, which is never going to be fully repaired because of the things that have been said and done along the way, you have a solution that neither of you like at all. And I just don't see why you wouldn't opt for route one rather than route two.
And put like that, Neither do I. But then that is your job. Marcus, thank you very, very much. And I'm looking forward to seeing this as part of the FMA conference at the end of September and on the 1st of October. And thank you so much for giving up your time.
Thank you for having me, and I wish you all the very best with the rest of your conference. I hope it all goes as smoothly. Thank you.
Hello again. I hope you enjoyed that workshop on arbitration and early neutral evaluation. This is just a postscript to let you know that in addition to the very clear guidance written paper that Marcus has provided, if any of you have any questions, Marcus has kindly agreed to answer those. So do please get in touch with any follow-up questions that you might have, and either to me directly or at the normal FMA address, info@thefma.co.uk, and Marcus will try and answer them as best he can. In any event, I very much hope that this workshop has helped you to incorporate the ideas of arbitration and early neutral evaluation into your mediations. Thank you very much for watching.